Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, been holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for Hi, Billy. StreamYard and me, we're fighting today. Does the fact that my ex-husband took a new wife wasn't that bad? Likelihood of somebody spouse me, just something I've been pondering. I know StreamYards is a love to hear, but I know it's very hot. In solidarity, I'm wearing a bathing suit. It looks really cute, and because when else am I gonna wear it? If you stupid.
Everybody know you, Mr. Ndukwe. How are you doing?
I'm fine, George. How are you?
Good.
Yeah.
Hold on, I'm still letting people in.
What's going on, Joey?
Me too, Judge. Okay, hi, hey now, Christopher. Tell me what you guys had for dinner. If you didn't like what you had for dinner, tell me.
I
think he
heard
you, Mr. Ndukwe.
Yes.
Okay.
Come by next time you're around in the building. Come say hi.
Jesus Christ.
Yeah, you should come by and say hi to us.
I will.
All right. So in keeping with compliance of the Texas Open Courts Act, we are streaming live on YouTube. And the courtroom is also open as well.
Okay.
Okay, Mr. Ndukwe, I see you're here. Your client is here. You ready to proceed?
Yes, Your Honor.
Okay, and Mr. Ramirez? Okay,
Yes, ma'am.
okay. We're just waiting on your, is your client down there at the bottom, Mr. Smith?
No.
Oh, no, that's a different case. Okay, well, as soon as your client get here, we'll go and take your case up next.
Thank you, Your Honor.
You're welcome. All right. You ready?
I'm ready.
Okay, we are on the record in cause number DF2217751. Counsel, would you please announce for the record?
Vincent Ndukwe, representing the petitioner, Terry Nicole Chenor.
Okay, just to clarify, for clarity, Christopher Angleby has been a member, very supportive for 7 whole months. Thank you. Chris, I didn't let me know. Dude, that's right. Look alive, people. Here, get onto it. It seems to work better when I'm not talking. That's what Ed. Thank you, Liz. I go for tacos. Thank you, Graham. Thank you for the mic.
somebody else I missed. Jim Huntsman, Jim H. Sorry, didn't mean to dox you. Super fan extraordinaire. Appreciate you, Jim. Oh, is this going to be my thing? Naming things about people? That reminds me of a story. Let's hit the in a minute. I need somebody to remind me. Just say, just remind me, Andy. Soccer Andy. Okay. Soccer Andy in a few minutes. Thank you. Love you. Um, Soccer Andy, and I'll tell you a story.
Right hand. Do you
Yes.
swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may put your hand down. Mr. Ndukwe, you may proceed.
Miss Chanel, tell the judge your name.
Perry Nicole Chanel.
You are presently, strike it. You have a child by name Sky Maria Harper, is that correct?
Yes.
That child was born on February 23rd, 2021, is that correct?
Yes, sir.
Who is the father of that child?
Beyonce Deshaun Harper.
Okay. And then today, you're asking the court to adjudicate Mr. Deonta Deshaun Harper as the biological father of the child.
Yes.
I'm making as well adjudication, making the legal father of the child.
Yes.
And establish a parent-child relationship between the father and the child. Is that correct?
Yes.
You and Mr. Deonta Harper used to live together. Is that correct?
Correct.
But you guys are no longer together at this time.
Right.
Okay. And is it because that the man had been violent towards you?
Yes.
Can you tell the judge a little bit about the history of violence he have perpetrated towards you and the child?
Presto. Hi. It's been so long. Yeah, she's a real judge. I know. I did some research. She's a real judge. These are real hearings. That's right, baby. How are you?
Maybe 3 days after discussing going our separate ways, I came in from
You gotta
work.
speak loud so that she can hear you very clearly.
I work night shift, so I came in maybe about 7 a.m. to take a shower. He came in pretty much harassing me. My mom had already told me to ignore him, so I did. I guess that kind of agitated him. So from the shower started the fight. He choked me. I had pulled a knife on him. I ended up being outside naked. The fight continued for maybe.
Okay, that escalated very quickly. Hi, Colin Raiders. Thanks so much for being here. We're gonna need to back that up just a little bit here. I'm pretty sure she just went from caressing, shower, to pulling a knife. I'm a little perplexed, but we're just getting started. If you're just getting here, tell us what you had for dinner. If you didn't like what you had for dinner, tell us what you wish you had for dinner. Say hello. We don't know what this is, but this is Judge Vonda Bailey. You may recognize her from what you thought was, well, what were fake court cases, but she is indeed a real judge, and these are real cases. Wahoo! Oh yeah, naked. We got that too. Thank you so much, by the way. You're great. All right, let's continue. Let's see.
30 minutes. And then by the time I picked up one of my phones to call my family, he had came out of nowhere and punched me 3 times. So I kind of just woke up kind of dazed. And from there, he had got.
Damn it. Wait, we were gonna go back. We're gonna go back. Hold on. I need to hear it again. Let's go back like 20. There we go. We're 46 seconds back. Here we go. Lisa
Can you tell me and the child?
Maybe 3 days after discussing going our separate ways, I came in from
You gotta
work.
speak loud so that she can hear you very
I
clearly.
work night shift, so I came in maybe about 7 a.m. Take a shower. He came in pretty much harassing me. My mom had already told me to ignore him, so I did. I guess that kind of agitated him. So from the shower started the fight. He choked me. I had pulled a knife on him. I ended up being outside naked. The fight continued for maybe 30 minutes. And then by the time I picked up one of my phones to call my family, he had came out of nowhere and punched me 3 times. So I kind of just woke up kind of dazed. And from there, he had got his oldest child is a male. He was 4 years old at the time. He grabbed his son and he left. I called the police. The police showed up. We got the police report. He ended up calling me like 3 times while the cops were there.
Okay, is there another incident of domestic violence?
Okay, that's one big incident we need to go over. MB, hi. Okay, summary, Paisley. The incident started with her in the shower. He attempted to caress her, then she jumped very quickly she pulled a knife on him, and then they were outside. They fought for 30 minutes, which is a very long time. If you've ever been in a fight before, I know it feels like a long, long time, right, Navar? But it is not usually, but 30 minutes seems like a long time, a very long time to be fighting outside without somebody else calling 911. But again, I'm just hearing this for the first time. So let's all listen together. We're only 11 minutes in. Usually I'm still doing an intro at this point.
I don't want you to spend the whole day telling the story. So, what other things has he done to you that you believe constituted violence towards you?
There was another incident with my oldest child were involved. We were on the play fighting, me and his 4-year-old son, and my 1-year-old son, and my was 6.
Miss Chanel, we can't hear you.
I told you gotta speak up.
Mr. Ndukwe, is it possible that y'all could switch?
Let's do that.
Thank you.
Can you hear me?
Yes.
Okay, so there was an incident where we were play fighting. Then my daughter jumped in, and I wasn't even turned their direction. I was playing with my baby girl and his son, and she just ended up screaming. And I asked him what happened, and he acknowledged that she put her nails in his skin. And we both are aware that my daughter has no nails because she bite her nails. So from that incident, another fight broke out. He ended up putting a pillow over my head. My daughter kept trying to jump in the fight to stop him. I kept having to push her away. That fight went on for maybe 30 minutes as well.
Okay, without telling the whole your whole life history. So they're having other incidents of domestic violence. If we spend an hour here, we take the time of the court. Is that correct?
Yes.
Okay. So you are asking the court today and to make a specific finding that there have been a domestic violence, child neglect, abuse 2 years before this petition was filed or during the pendency of this case. Is that correct?
During the case, has been harassment.
Listen to the question. So you have already told the
I guess bring it. Bring it to Canada, Judge Bailey. I don't think she will. This is real court. This isn't her proprietary YouTube channel where she's faking court, which would be, I guess, still reactable under fair use. But this is even more so. This is a fucking public court. Bring it.
the violence involved. Okay. So you are asking the court to make a specific finding that there have been a domestic violence either 2 years before this divorce was filed or while the case is pending. Is that correct? Either or.
Either or. It was last year's battle.
Yeah, that's within 2 years. Is that correct?
Correct.
Okay.
Correct.
And as a result of that domestic violence and abuse, you want the court to appoint you sole managing conservator. Is that correct?
Correct.
And with the exclusive right that was associated to so managing conservative. Is that correct?
Yes.
And you don't want the judge to put any kind of geographic restriction on your rights to determine the primary residence of the child. Is that correct?
Correct.
Because he will be still chasing you around.
Correct.
And you're asking the court to make a finding that you don't want your address to be disclosed.
Correct.
And he know if you want to see the child, he know how to see the child. He know where your family is.
Correct.
And you want the judge to limit his visitation, and you want it to be supervised.
Correct.
By a competent adult at your chosen.
Correct.
And the time of visitation should be arranged between you and him. Is that correct?
Yes.
And then you want the judge to order him to pay child support beginning on March 1st. We're supposed to do this proof up before. So you want the child support to begin on March 1st this year. Is that correct?
Correct.
And you want Mr. Hopper to provide the health insurance for your child. Is that correct?
Correct.
You believe the request you are seeking on page 14 of your final order, you are asking the court to restrain Mr. Hopper from using any kind of corporal punishment on your child.
Correct.
Because he has been violent towards you.
Correct.
You don't want him to be violent towards your child, even when he was given an opportunity to visit. Is that correct?
Correct.
And you believe that the request you are seeking, the relief you are seeking today, is in the best interest of your child.
Yes.
And regarding the relief you are seeking that you don't want to disclose your address, you believe is in your best interest and the best interest of the public.
Yes, I do.
And you are asking the court to approve the order that you have submitted to the court.
Yes.
Georgia, I filed three orders. The last one is the one we're going by.
Okay. I believe that's the order that I have in front of me, Mr. Ndukwe. I do have, well, I'm sorry, are you finished with your client's testimony?
Yes, Your Honor.
Okay, I do have a question. I need to hear testimony about how she came to the amount of child support that she's asking the court to award.
Okay. Mrs. Chanel, when you are living with Mr. Hopper, how much was he bringing home at that time?
At the time, he was making about 18 an hour.
Okay, so that's how you calculated the child support. Is that correct?
Correct.
You don't know if he's making more or less at this time.
Correct.
But that's what you know he was making at the time the petition was filed.
Correct.
And you want the judge to, you believe he may have even getting a promotion because he has been in that job for a long time.
Well, not for a long time. He discussed that they wanted him to start driving trucks.
Driving truck.
That would be a promotion.
So that would be a promotion.
Correct.
So, but you want the judge to issue child support based on the amount we know. Is that correct?
Correct.
How's the witness, Your Honor?
Thank you. Okay, Mr. Ndukwe, I made a slight modification to your, well, let me make sure I'm looking at the right decree. I see not decree, the order. I see an amended final order in the SAPSER filed on February 17th, and then I see the default order filed February the 20th. Is the 20th the one that's the most recent? That's the one you're saying you're trying to file with the court?
Judge, can I email it to Joe?
I think I have both.
If it's the last one, I thought it was accepted. I don't know. I look in the system. I don't know what I was withholding. I was accepted on 24th or the order.
Okay, so then
That's true, Grim, but I just want to point out something. If you happen to be here watching this right now, I just want you to know that you might be addicted to court, and that's okay. We don't judge around here, but you may have in fact witnessed more actual court hearings than a real lawyer. Because a lot of lawyers actually don't spend a lot of time litigating in lawyer is StreamYard. Stop silencing me, StreamYard. Anyways, most of what lawyer is negotiating favorable things for your client, talking to other lawyers and other people. It's not being in front of a judge making those epic arguments that we all think of. So, in fact, weird, but most lawyers even think it's weird that we watch court. Seriously, there's a couple here. They tell me.
Made a slight edit to the income withholding order in terms of when you wanted the date to start. All right. So the court, after hearing testimony, the court will grant the order as it is written. The court also finds that Deontay Harper was served with notice of the petition on December the 27th, 2022. That notice has been on file with the court since January 3rd, 2023. He did not file an answer and did not sign a waiver. He is made wholly in default. The court has signed the order, Mr. Ndukwe, and you and your client will receive a copy of it today.
Thank you, Judge.
Welcome.
Are we excused?
Yes, thank you for
Thank
being
you.
here.
Thank you.
You're welcome.
I must sit. See
Okay,
you later, Miss Joey.
Bye, Vincent. We'll see you.
All right.
Mr. Ramirez, could you give me one moment? I have someone that just walked in the courtroom.
Of course.
Thank you.
Judge, yeah, you go right ahead. We're going to talk here while you do your thing. She's smart enough to have muted herself, which is awesome. If you're just getting here, we're watching this judge. We've actually watched her once before, but she's fairly new for us. If you would like to tell me your favorite adult dessert, you know, the dessert that you don't share with kiddos, not because you can't, but because you don't want to, I would love some inspiration of decadent, delicious desserts that you like to share. Only for adults. Now, that can be as simple as Oreos. I know people, like adults, that keep.
Okay, Mr. Ramirez.
No, Judge, we're talking about desserts for a second. We're going to let everyone flow those into the chat. What I'll say is, when I was a kid, my mom kept shortbread secret. You know? Ooh, lemon meringue pie. It sounds like it will be wasted on little children. Running these up on the chat. Put it on in the chat and we'll listen. Fucking StreamYard. Is tie-dye a bad choice for court? Tell me.
Good morning, Your Honor.
Good morning. You doing okay?
I am doing well. How are you?
Good, good. Ready for the weekend.
Yeah, it's coming up.
Yes, it is. I like to call Friday. Even
Friday.
if I don't have anything to do.
You're like, I'll just do all the defaults that day so I can move on through them faster, you know? Yeah. You're like, get all these defaults out of my docket. I accomplished something this week, and you go home, have a good weekend. Yeah.
Yep. And then your client has a good weekend. You have a good weekend.
That's right.
All right. So are you and your client ready to proceed?
Yes, Your Honor.
All right.
I'm ready.
Okay. We're on the record in cause number DF2214774. Counsel, would you please announce for the record?
Yes, Attorney Raul Ramirez for petitioner Elizabeth Perez Faz.
Okay. Ms. Perez Faz, would you please raise?
Asking thank you to Mary Brown. Right. Yard. I hope not. Will they take our computers and phones away because we're addicted? I hope not. I hope not, but thank you so much. Also, I live in Canada. Let's pretend I live in the remote part of Canada, and that's why my internet is terrible. It's not true.
Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do, yes.
Thank you. You may put your hand down, and Mr. Ramirez, you may proceed.
Yes, Your Honor, before I proceed with my client's testimony, I ask the court to take judicial notice of the original petition and suit affecting parent-child relationship, which was filed with this court on September 28th of 2022.
Okay. The
I
court,
ask-
go ahead. I'm sorry.
No, go ahead, Your Honor. I'll go one by one.
Oh, I was gonna say the court is going to take judicial notice of all of the contents in the entire file.
Okay, thank you, Your Honor. Specifically, I would ask the court also take judicial notice of the affidavit of return of service, which states that the respondent was served on Thursday, December 15th of 2022, and that return of service has been on file since December 19th of 2022.
Got it. The court takes notice.
And I will call my client, Elizabeth Perez-Foss, for testimony.
Okay. You may
Uh,
proceed.
Okay, Ms. Perez, could you please state your name for the court?
Full name Elizabeth Perez-Foss.
And Ms. Perez-Foss, both you and your son have been a domiciliary of Texas for the preceding 6-month period before you filed the original petition in suit affecting parent-child relationship, correct?
Yes, that is correct.
And both you and your son have been residents of Dallas County for the preceding 90-day period before the filing of the petition.
Yes, that is correct.
And what is the name of your son?
Adian Israel Gomez,
And when was his birthday?
February 15th, 2012.
Okay. And the respondent is Mr. Israel Scott Gomez, right?
That is correct.
And he's the biological father of Adian.
That is correct.
And you have submitted a proposed order in suit affecting parent-child relationship to this court, is that right?
Yes, that's correct.
And then that order, you're asking the court to appoint you sole managing conservator of the child and appoint Mr. Gomez possessory conservator of the child, is that right?
Yes, that is correct.
And you believe that's in the best interest of the child?
Yes,
Okay. And you have also put a possession schedule where the possession of the child will be by agreement only, is that correct?
that is correct.
And this, you believe this is in the best interest of the child?
By agreement only is actually unusual for the state of Texas, even though I did do the disclaimer earlier and using Canadian internet. That's true. I watch American. Well, Georgia. There are 5. Okay, I'll stop talking, StreamYard. Fuck you.
You're basing this predicting of a controlled substance with intent to distribute, and the times you have offered him to see the child, he exercises very sporadic possession, is that right?
That is correct. Yes,
And so that's why you believe it's in the best interest of your son that the possession will be by agreement only.
that is correct. Yes,
And you're also asking the court to order him to pay child support in the amount of $674.17.
yes, that's correct.
And you arrived at this amount based on what you believe are $4,000 in gross monthly resources, right?
That is correct. Yes,
And you arrived at this amount based on your conversations and interactions and him disclosing to you that he has made these amounts in the past.
yes, that's correct.
Okay. And so based on 4,000 monthly resources, you believe that $674.17 is the correct amount based on the child support guidelines, according to the family code.
Yes,
And you believe that's in the best interest of the child.
I do. Yes,
Okay. And now you also made a pleading for the court to award retroactive child support based on the fact that the respondent has not paid child support. Is that right?
that is correct. Yes,
And you're asking for the maximum of the statutory limit of 4 years based on $674.17 per month for a total of $32,360.16. Is that right?
yes, that's correct.
And you believe that this retroactive child support is in the best interest of the child?
Yes, I do.
Okay. And you currently have been obtained new employment, correct?
Yes, that's correct.
Okay. And your employer has a window for offers health insurance, is that right?
Yes, that's correct.
And when you qualify, you will explore enrolling your son in that health insurance policy as well.
Yes,
Okay. And you have submitted an order in suit affecting child relationship which bears your signature to the court,
Yes,
and you're asking the court to sign that proposed order in suit affecting parent-child relationship.
yes.
Your Honor, I'll pass the witness.
Thank you, Mr. Ramirez. I have a couple of questions for Ms. Perez. Let's see. I'm missing testimony, or maybe you can point me to it. I see that she talked about asking the court to appoint a sole managing conservator,
Mhm.
and that being in the best interest of the child, but I do not see any testimony as to why she was making that request.
Yes, I believe she testified that the respondent has been previously convicted of possession of a controlled substance with intent to distribute, which is a felony. And so based on this conviction, she does not believe it's in the best interest of the child, considering the drug history of the respondent.
Okay, that's what I'm missing then. So could you have your client speak more about the drug history as it relates to the child specifically? Because that within itself, the conviction of a felony wouldn't necessarily bar him from being a joint managing conservator.
Okay. Miss Perez, are you concerned that based on the respondent's history and conviction that he may use or have drugs in his possession?
Yes, I am concerned.
And does this based on that concern, are you afraid that perhaps he may be either using or dealing if he had possession of your son?
Yes,
Do you think that may put your son in danger?
yes, I do.
And is that reasoning why you're asking the court to grant you the sole managing conservator?
Yes, that is.
Your Honor, I think that should suffice on the fear factor.
It does. And
The fear factor. Fucking great television show from the early 2000s. If for some reason you were sheltered in a way that you didn't factor.
proactive child support, the court is not going to award that right now, because in terms of the numbers, we would actually need the Attorney General present to give the exact calculation of that, and the order doesn't have enough language in it
Okay.
that would be specifically related to it. But that doesn't mean the court won't entertain it, on a subsequent motion. We would
Okay.
just need those numbers from the Attorney General.
Okay.
And if you'll give me an income withholding order, that would be great.
Yes, Your Honor, I don't believe my client knows where the respondent is employed. He doesn't communicate that much to her. So if, we'll explore that once we actually have that information, if she's able to obtain it.
Got it. Okay. Is there anything further from your client?
No, Your Honor.
No, Your
Okay.
Honor.
The court
Sorry.
after hearing, go ahead, Mr. Ramirez.
Yes, so Your Honor, so I guess the language about the retroactive should only be a line down the decree. I'm assuming the court is just going to strike that line from the order.
Yes, I did.
Okay, perfect. Okay, thank you, Your Honor.
You're welcome. The court, after hearing the testimony, the court will grant the request as ordered, just with the slight modification of the retroactive child support being crossed out. And when the time is appropriate for the income withholding order, the court will sign off on the income withholding order. The court also finds that the respondent was served on December 15, 2022. And that notice has been on court, their return rather has been on file with the court since December the 19th of 2022. The respondent failed to file an answer or a waiver, so he is by wholly made in default. And the order has been signed, and you and your client will receive a copy of it today.
Thank you, Your Honor. May we be
Thank you, Your
excused?
Honor.
You're welcome. Thank you. Yes, you may be excused. Okay, good morning, Mr. Sullivan. See who else we have. Is it Frias?
Good morning, Your Honor.
Morning, good morning. And I see a James. James, what's your last name? Oh, hold on. You should have gotten a prompt that's asking you to unmute.
Smith.
Okay, what's your last name?
Smith.
Smith. Thank you, Mr. Smith. How are you?
Wonderful.
Good, good. Let's see. Okay. Mr. Sullivan, your case, is it the James Smith and Christina Medina?
No, it's a Venegas case. Is that on your docket or am I in the wrong place?
You know, you might be in the wrong place. You might need to be in Judge Lee's.
Let me fix that then. I'll get over there. Thank you, Judge.
You're welcome. No
It's a bathing suit, but thank you.
problem. Mr. Smith,
Yes, ma'am.
okay, you are ready to proceed?
Yes, ma'am.
1 second. Do you have the questions that you need to answer, or did you need me to ask those questions to you and you answer?
I would need you to ask those questions and answer.
Okay, okay. 1 second. No. 11597. No children. I'm getting that
No, ma'am.
page right out so I can ask these questions of you. And I see that you did file the certificate of last known address and non-military status. Thank you.
Yes, ma'am.
Okay. And I believe I have your order too. Did you revise that order, Mr. Smith?
I did.
Okay. Because I'm not seeing you having an email that you can send to me?
I got an e-file email back saying it was accepted of the revision.
Okay.
And it was just, I had to check block 6 or something.
Okay. There are a couple of blocks. Okay, I see block 6 checked. Okay, I think I'm looking at the right one.
Okay.
Okay. Okay. Are you ready to proceed? Mr. Smith?
I'm ready when you are.
Okay. You ready?
I'm ready. Friday.
Friday, that's right. Okay, we are on the record in cause number DF221597. Mr. Smith, would you please identify yourself for the record?
You guys, say it with me now at home, please. What's tomorrow? It's Friday. Oh my God, I love it. Do you know what that shows? More than anything, that he was listening. That's all that's what that tells me. He was fucking listening. Okay? James, listen. Next time, I would not recommend wearing neither a bathing suit nor a tie-dye shirt to church, or to not to church, to like I've ever been to church, to court, but you're listening, and that is very, very important. Good job. I'm proud of you. That's going to go over well. No matter what, you do a callback with a judge from something they said earlier in a docket, it will go over perfectly. I'm not kidding.
James Austin Smith.
Okay. And Mr. Smith, you are representing yourself in this case, is that correct?
Yes.
You're the petitioner in this case?
Yes.
Have you been a resident and a domiciliary, I always get tripped up on that word, domiciliary of Dallas County for 6 months preceding the filing of this divorce case?
Yes.
You and the respondent, which day were you all married on?
I don't remember.
Okay, okay.
Okay, that's gonna be it. James? James! James, I just gave you a really great shout out for how thoughtful you were, how much you paid attention. Okay? You're making me look like shit, James. What the fuck, man? I was trying to help you out. Jesus Christ.
We were married in Las Vegas, September 21st, 2019, I believe.
Okay, and since that time, the two of you have separated and stopped living together. Is that correct?
That's correct. We haven't been in contact or together in over a year.
All right. The marriage has become insupportable because of discord or conflict of personalities between the two of you, and that has destroyed the legitimate ends of the marriage relationship. Is that correct?
Absolutely.
Is there any chance of reconciliation?
Absolutely not.
Okay. Were there any children born or adopted of this marriage?
No.
All right. Do you, to your knowledge, is your wife pregnant at this time?
Absolutely not.
Okay. Any property that you all have, was there ever any accumulation of community property?
No, ma'am.
Okay, so you're just asking that your personal assets are yours and her personal assets are hers. Is that correct?
Yes.
Okay. Let's see. Do you know if your spouse is asking for a name change?
I have no idea.
Okay. All right. Are you asking the court to grant your divorce today?
Yes.
Okay. Oh, it was something else I needed to ask you. Christina Medina, she was served with a copy of this petition. Is that correct?
Absolutely. You should have record of that.
She was served on October 8th of 2022. Is that right?
Correct.
And the return of service has been on file with the court since October the 31st of 2022.
Correct.
Okay. Does that conclude your testimony?
Yes, ma'am.
Okay. Mr. Smith, I grant your divorce today. And as stated in your decree, Ms. Medina, the respondent in this case, she was served on October the 28th of 2022. The return of service has been on file since October 31st of 2022. She did not file an answer, nor is there a waiver on file. So she's made wholly made in default. And your decree will be sent to you here shortly. There are some blocks that I'm going to fill in and just put NA that is not applicable according to the testimony you gave here today. Okay?
Yes, ma'am. And then do I file that with the clerk?
No, you already did it. I have it. So I'll be sending it to you. Well, I won't do it. My coordinator will be doing it.
Friday.
Friday. That's right. Have a good weekend.
Thank you. Bye-bye.
Bye-bye.
Oh, that's one of the best divorces I've ever seen. Tell me I'm wrong. Tell me I'm wrong.
Okay, Mr.
Friday,
Alcorn.
baby.
Yes, ma'am. My first time in front of you.
How are you?
Oh, I'm
Oh, sir, what an opener. Ah. Had too long by myself. Situation, please. Can I? Look at how big her smile is. Because we ladies, we like it. And wooed.
doing fine. I don't think it's my first time to see a judge, but at least my first time in front of you.
Yes, this is our first time meeting. Nice to meet you.
Good to meet you too. It's good to hear a cheery voice on Friday.
I know, right? It's Friday.
It is.
Okay. I see your client is present.
Yes, ma'am.
Are you all ready to proceed?
Yes, ma'am.
Okay, just pull your case up.
Who is the political prisoner? He's a hostage. This whole conversation between the judge and the lawyer. What is going on?
I'll, Vincent puts his in front, I put mine behind, yeah.
Oh, that's funny.
Yeah.
Okay, you ready? All right, we are on the record in cause number DF 2215666. Counsel, would you please announce for the record?
Jerry Alcorn, attorney for Dat T and Win.
Okay, Mr. Nguyen, would you please raise your right hand? Do you swear or affirm the testimony you'll give will be the truth, the whole truth?
Yes.
Okay, you may put your hand down. And Mr. Alcorn, you may proceed. Mr. Nguyen, could you come up to the microphone a little closer? My court report.
You have permission to move, Mr. Nguyen. Even if Jerry, is it Jerry? Doesn't look like he's giving you permission, you closer to the
He has to
camera.
write down everything that you're gonna say. Okay.
Mr. Nguyen, isn't it true that you and your wife lived in Dallas County for 6 months prior to filing your petition for divorce?
Yes.
And that there are no children in the marriage and none expected?
Yes.
And this marriage become insupportable because the last time you saw your wife was on June the 5th, 2022.
Yes.
And that you've contacted her, all the relatives you know, all the friends she know, and they were not able to tell you where she's located.
Yes.
And you also did an internet database search and
Hold on. I'm gonna answer this call. I gotta take this call. We're gonna listen.
search, but the only thing you have is her driver's license number, and you were not able to locate her using the driver's license number.
Yes.
And she was served by posting, and that return of service was filed on February the 8th, 2023. Is that correct?
Yes.
And during the marriage, there's been virtually no assets or liabilities accumulated.
Yes.
And you're asking the court for a divorce today.
Yes.
Oh. Mr. Alcorn, does that conclude your client's testimony?
Yes, ma'am.
Oh, okay. I was waiting on you to say this.
Oh, passed away. Okay.
Baby plaid emergency, not a bad emergency, just an anti-emergency, you guys. I don't even fuck. My sister had a baby recently and she needs my help. I'm so
If you want me to say how do you pass a witness or conclude it, I'll do it.
It's okay. I thought the signal dropped or something for a minute.
Yeah.
Okay.
Well, you know, I don't, there was a judge about 25 years ago in Dallas County, and he schooled me 6 questions for, no assets, no kids, 8 questions for, children, and 10 for name change. And if you ask any more, he would,
Well, no, whatever you think is appropriate to prove up your case,
whatever you think's appropriate, I'm happy to do. Every judge has their little things. And but I always say, is it true there's no children in the marriage? And if they give a yes, I say, I'm not gonna, whoa, I guess you're pregnant. You said your wife wasn't. I've done that before too.
Oh, that's hilarious.
I know.
Well, the court, after hearing the testimony, the court grants the divorce. The court finds that the respondent was served in this case by posting on February 8th of 2023. That notice was well, I'm sorry, it was January 25th, 2023. That notice was posted here at the George Allen Court Building. It has been on file with the court since February 8th of 2023. The respondent did not file an answer nor waiver, so she is made wholly in default. The decree has been signed, and thank you for the statement of evidence as well. It's been signed too.
All right, thank you very much.
You're welcome. Have a good day or a good weekend.
You have a good weekend too.
Thank you.
Bye.
Bye-bye.
Okay, we're gonna call it. I know that I'm a terrible person. I'm a terrible host, except I'm not. I'm a really good auntie and a sister. If you're confused, I want baby snuggles immediately. And normally I have to schedule that. And yet tonight, so everything. Even this docket tomorrow, that was the case. God damn it. Everything, the internet's terrible today too. Like, it's not just me. The internet is just terrible. Anyways, I will see. Yay. If you would do me a solid, go ahead to the video. It's really helpful. Ambulance, that's epic ambulance lore. I will say hi to the baby and take some non unallowable. Dude, I pay money for StreamYard and it's just so and I will see you in the next video.
One by